Hello, everyone. Welcome to Work Ready, Workers' Rights. I welcome you this morning to our very important program. Work Ready is a program running from December of last year to December of this year, which is aimed at helping people affected by COVID to get a job or to improve their current work situation. So that means get a promotion, get a raise, and plan a more sustainable career path. We're doing that in 3 different ways. Number one, we're lending out laptops and Wi-Fi hotspots for 6-week periods out of 20 library locations. And to take advantage of that, all you have to do is go to our library website, lacountylibrary.org, click on the Work Ready, and then there's a registration form that you fill out. It has 5 questions. You choose which library you want to pick up a laptop at, and we'll send you an email with all the instructions. Once again, lacountylibrary.org, click on Work Ready. It's right in the middle of the screen. The second way we're helping folks with Work Ready is doing events like this, live events throughout the year on all sorts of work-related topics like workers' rights, resumes, cover letters, how to plan a career. Next week, we have a program on getting a job if you're 50 plus for our older adults out there. And the third way we're helping people is we're buying the latest and greatest work-related materials. So when we're talking about books and ebooks on any work-related topic and skill that you can think of. So you can go to the library and see those items there. You can place them on hold via the library website, or you can get the ebooks right on your computer without even leaving your chair. And that is the Work Ready program. And now I would love to introduce you to our speakers for today. We have wage enforcement investigators, Perla Molina, Ronnie Manucci, and Tiffany Tum from the County of Los Angeles Department of Consumer and Business Affairs Wage Enforcement Program. The Department of Consumer and Business Affairs serves consumers, businesses, and communities through education, advocacy, and complaint resolution. DCBA counsels consumers on small claims court litigation, investigates complaints, mediates disputes, assists with small business inquiries, and enforces the LA County and City of Santa Monica minimum wage ordinances, hero pay, public health anti-retaliation, and employee paid leave for expanded COVID-19 vaccine access ordinances. All of these things you'll be hearing about today. Today's presentation will cover the Los Angeles County and City of Santa Monica minimum wage ordinances, as well as hero pay, public health anti-retaliation, and employee paid sick leave for expanded COVID-19 vaccine access ordinances, among other worker protections. Ronnie Manucci and Tiffany Tum will be presenting the English version of the training, which will be starting in just a moment. And Perla Molina will be presenting the Spanish version, training later on today at noon, directly after this program. And so with that, I am very happy to turn the stage over to Ronnie Manucci and Tiffany Tum.
Thank you, Ulrich. I'm going to be sharing my screen shortly.
Is it letting you get the share screen, Tiffany?
Yeah, I can do it now.
Okay.
Good morning, everybody. My name is Tiffany Tum, and I'll be covering the English portion of the Los Angeles County and the City of Santa Monica minimum wage ordinances, paid sick leave provisions, overtime on federal and state levels, meal and rest breaks, and first-time learner provisions. And my colleague Ronnie Manuki will be covering unionized employees, public health anti-retaliation ordinance, zero pay, and employee paid leave for expanded COVID-19 vaccine access ordinance. Effective July 1st, 2016, the minimum wage increase in the unincorporated areas of LA County. The Board of Supervisors passes ordinance to help our lowest wage workers in the county. The minimum wage ordinance has two schedules, large employer and small employer. Large employer is any employer with 26 or more employees, and small employer is any employer with 25 or fewer employees. Effective July 1st, 2021, the minimum wage for both large and small employers are at $15 an hour. We determine an employer size based on the average numbers of employees working for the employer during the previous calendar year. If the business did not have any employees in the previous year, then they are considered a small employer. Beginning January 1st, 2022, the Board of Supervisors will be determining the next wage increases based on the CPI, Consumer Price Index. Please keep in mind that the minimum wage increases were not delayed due to the COVID-19 emergency. Who is an employee and who is covered under our ordinance? An employee is anyone who performs at least 2 hours a week in unincorporated LA County. This includes part-time employees, full-time employees, nonprofit employees, and employees who are entitled to the payment of minimum wage law under California minimum wage law. Government and public school employees are exempt from this ordinance. As mentioned earlier, the ordinance only covers employees who work in unincorporated LA County. If you are not familiar with unincorporated areas of LA County, we use county resources to determine jurisdiction. That includes the register recorder, the referral address verification system, and the Department of Regional Planning database. Besides from paying employees the correct minimum wage, every employer must also post a minimum wage ordinance poster in a conspicuous place within unincorporated LA County. Conspicuous place means any place that can be easily seen by anyone. That includes employee break room, clock in and clock out area. This poster covers the current minimum wage rate and employees' rights under the ordinance. The posters must be posted in English and Spanish, 8 by 14 inches in size. In any case that the employer does not have a physical location within unincorporated LA County, employer must provide the notice each year to employees who perform work in unincorporated LA County. Los Angeles County Minimum Wage Enforcement Ordinance gives the CBA the authority to enforce the provisions of the ordinance. By identifying the violations of the ordinance, we must ensure that employees are paid the correct wage, ensure the employer does not retaliate against employees who inquire about the ordinance. The retaliation can include reducing hours of the employees, reducing the pay, and threatening to terminate them. As investigators, we must make sure that employer is in compliance with the posting's requirement, and it must be posted in a conspicuous place. BCBA investigators must be given access to payroll records at all time of request. The purpose of the Wage Enforcement Program investigation is to find facts and that will allow DCBA to identify and address violations of the ordinance. DCBA will utilize the complaint-driven and proactive strategies to ensure that violations are identified, addressed, and remedied in a timely manner. Directive investigation means that we can walk into any businesses at any time during normal business hours in unincorporated LA County to request for records. And complaint-driven investigation means that it's any complaint submitted through a phone calls, reach help, or our website. Additionally, every employer must keep the records for at least 4 years. Employer must allow DCBA access to payroll records to interview employees during normal business hours, and they must cooperate with DCBA investigators. During the compliance visit or investigation, if the investigator identifies a violation of the ordinance, BCBA investigators may issue a correction order to the employer. The correction order must identify the violations to be corrected and give a reasonable amount of time to correct the violations. After we wrap up the investigation part of the find that the employer has violated the ordinance, we move on to issuing the wage enforcement order. The employer is required to post the VO up within 24 hours of receipt. Similar to the county, the city of Santa Monica also adopted the minimum wage ordinance to help the lowest wage workers in the city. The CBA investigators enforces the city of Santa Monica minimum wage ordinance on behalf of the city. Employees who work at least 2 hours a week within city of Santa Monica are subject to the city of Santa Monica minimum wage ordinance. And you can also verify jurisdiction through the register recorder. The city's ordinance also has two schedules, large and small employers. Effective July 1st, 2021, the minimum wage for both are at $15 an hour. Aside from the minimum wage, another provision that Santa Monica has is the hotel worker living wage. The hotel minimum wage is aligned with the City of LA hotel wage and increases annually by the CPI. A hotel worker is any individual who works at a hotel and employed by either the hotel directly or someone who's in contract with the hotel employer. Effective July 1st, 2021, the minimum wage for the hotel is at $17.64 per hour. Another provision of Santa Monica ordinance is that the employer is required to have the legal notices in English and Spanish, and also in any other languages that is spoken by at least 5% of the employees. These legal notices inform the employees of their rights and the current minimum wage rate. The city of Santa Monica usually has these notices up around June prior to the July increases. At the time of hire, the employer is required to notify the employees of who they're working for, and they need to give them the names of the employer, the address, and phone numbers in the written notice. Another thing that Santa Monica has that is different from the county is the paid sick leave provision, which requires the employer to have, for the large employer to have at least, to provide 72 hours of paid sick leave a year, and small employer to have at least 40 hours a year, which both took effect in January 1st, 2028, and that has not changed ever since. This is higher than the state minimum wage, state requirement of the paid sick leave, and that's something we must look for during our investigation. Employees can start accruing through the accrual method or the front loading method. For accrual method, they must provide 1 hour for every 30 hours work, and for the front load method, they have to provide at the beginning of the year, and they cannot change it any time of the year until the next calendar year. The city of Santa Monica requires employers to retain their records for at least 3 years, and that is different from the county. And the statute of limitation is also 3 years. Retaliation is prohibited, and employer cannot take any adverse action against the employees who try to exercise their rights. Any form of retaliation can be reduction of hours, reduction of pay, threatening to terminate them. And they can actually be prosecuted under the city ordinance as well. Besides from LA County and Santa Monica, there are 3 other cities that had the minimum wage increase effective July 1st, 2021 to $15 an hour. And there are City of LA, City of Pasadena, and City of Malibu. For employees in any other cities that do not have the minimum wage ordinance adopted, they must follow the state minimum wage. It is currently at $14 an hour for a large employer and $13 an hour for small employer. And the next increase will be January 1st, 2022. Besides the city of Santa Monica, the city of LA also has their own paid sick leave provision. Employer who works at least 2 hours a week in city of LA for the same employer for 30 days will be subject to paid sick leave. Employer can either do front loading or accrual method. If front loading employees must be provided at least 48 hours earlier in either the beginning of the year, calendar year, or 12-month period. If accrual method, they must be provided 1 hour for every 30 hours worked. LA County, City of Pasadena, and other cities that do not have their paid sick leave ordinance must be referred to the state minimum wage. State requirement of the paid sick leave. And that is also 1 hour for every 30 hours worked. Federal and state overtime. The federal overtime provisions are in the Fair Labor Standards Act, FLSA. Non-exempt employees who are covered by the act must receive overtime if they work over 40 hours a week, and that's at least 1.5 times of their regular pay. As for the state provision, non-exempt employees must receive 1.5 times of their regular pay rate if they work more than 8 hours a day or over 40 hours a week. Meal and rest breaks in the state of California. If an employee works more than 5 hours a day, they must be provided at least 30 minutes of meal break, unless they work not more than 6 hours. If they work for 5.5, then they do not have to have the meal break. Employer must also provide a second meal break for at least 30 minutes if they work more than 10 hours a day, unless the total hours worked is less than 12 hours. However, a second meal break can be waived by mutual consent of the employer and employee if the first meal period was not waived. First-time learner provisions. This applies to both the city of Santa Monica and the state of California. First-time learners are workers who did not previously have a similar related experience can earn 85% of the regular minimum wage for the first 160 hours of employment. After 160 hours, you can get the full minimum wage pay. And these are the website for Santa Monica and the state of California to look for the first-time learner provisions. And that wraps up my portion of the presentation. Does anyone have any questions?
There are no questions as of yet. We did have a question about whether the presentation will be available to review, and the answer is yes. We will be sending out the slides this afternoon after the presentation, and then the presentation will also be on YouTube, probably next week. So keep checking back to our YouTube channel at youtube.com/LA County Library. And then Ronnie, I'm turning it over to you for the rest of the presentation.
Thank you so much. Hi, everyone. My name is Ronnie Manuki. I'm going to be continuing the presentation. Let's see. Tiffany, are you able to pull up the presentation?
Yeah, I can share.
Please. All right, thank you so much. So I'm going to be talking about unionization of employees first. So unions are in place to help workers with a variety of things in the workplace. Some examples include making sure employees have decent wages, affordable healthcare, job security, and etc. Union members work together during negotiation and enforcement process with management to ensure that all subjects that workers care for, such as decent wages, affordable healthcare, and job security, are achieved. The next slide, please. First, we will cover the recent and urgency ordinance that was passed on November 24th. Since March 16, 2020, the health officer has issued and continues to issue a number of COVID-19 related health officer orders that address the increasing and imminent threat to the public health and safety as a result of COVID-19. Prohibiting retaliation against employees who report or discuss non-compliance with COVID-19 related health officer orders will both promote the reporting of such non-compliance and allow the county to more quickly address the spread of COVID-19. This ordinance encourages workers to report public health violations without the fear of being retaliated against. In a workplace, no employer may discriminate in any manner if an employee reports, discusses, informs anyone regarding their employer's non-compliance under this ordinance, or belongs to a public health council or exercises their rights under this ordinance. The focal point of this ordinance is the word retaliation. So what is retaliation in this instance? Retaliation is any change or adverse action against a worker. Some of these actions include terminating the employee, demoting the employee, reducing the employee's hours, or reducing the employee's pay. This ordinance is applicable anywhere in the Los Angeles County outside of cities that have their own health officers, such as the city of Long Beach and the city of Pasadena. This ordinance is also not limited to the unincorporated parts of the Los Angeles County. The three links that you see on the presentation can be used to ensure that the employers do not fall into the cities that have their own health officer orders. It is important to understand who is considered a worker under this ordinance. A worker is any individual who performs any work within the geographic boundaries of County of Los Angeles, except with cities with their own health officers, such as Long Beach and Pasadena. Independent contractors, volunteers, government employees are excluded from this ordinance. It is also important to understand who is considered an employer under this ordinance. An employer is any person who directly or indirectly or through any agent or any other person, including through the services of a temporary service or staffing agency or similar entity, employs any worker or exercises control over their wages, hours, duties, or working conditions of any worker. Lastly, we want to ensure that all workers have the opportunity to report a complaint if they are experiencing any retaliation or know of someone who is. To report a complaint, one can contact the Department of Consumer and Business Affairs at 1-800-593-8222 or by visiting our website, which is www.dcba.lacounty.gov, or use the email noretaliation@dcba.lacounty.gov. In addition, workers may also file a complaint to the Los Angeles County Department of Public Health by emailing them at phcouncils@ph.lacounty.gov. The Department of Consumer and Business Affairs has been given the authority to act as an agent for the Department of Public Health to enforce and investigate provisions under this ordinance. The complaints received under this ordinance are highly time sensitive. The Department of Consumer and Business Affairs has 1 year to issue a finding when receiving a complaint against an employer. The Department of Consumer and Business Affairs also has the authority to issue administrative fines at the amount of $10,000 per violation per day to the employer. And the employer, however, has the opportunity of filing an administrative hearing as well. As far as the worker goes, any worker or the county council has a 3-year window from the employer's last violation to sue the employer in the Superior Court of State of California. During that process, workers may be reinstated back to their job if they lost their jobs. All actual damage, earn all compensation for all actual damages for the sum of $10,000 per violation or lost pay, whichever happens to be greater, and can be awarded for any punitive damages. And punitive damages are any damages that are not related to money. When notifying the employer, the worker or the county council must provide a written notice to the employer, and the employer has 15 business days to correct the alleged violation. So this written notice is essentially a fix-it ticket for the employer and gives them the opportunity to right the wrong within 15 business days. Now we will be moving on to the Los Angeles County Hero Pay Ordinance, which went into effect on February 26, 2021 for 120 days, and it expired on June 26, 2021. The purpose of the Los Angeles County Hero Pay Ordinance is to help grocery and drug retail workers who were not fortunate enough to be able to work remotely during the COVID-19 pandemic. These workers tend to also have minimal benefits and are low wage earners as well. The Los Angeles County Hero Pay Ordinance applies to grocery or drug retail stores that sell primarily food or household goods, or a variety of prescription and non-prescription medicine or miscellaneous items, or are over 85,000 square feet and dedicate 10% or more of their sales on the floor to groceries, or 10% or more of their sales floor to drug retail, and meet all of the following requirements. These requirements are: they operate at least one retail grocery store, retail drug store, or large retail store that includes a grocery or drug component to its retail sales in an unincorporated area. Either are a publicly traded company or employ 300 or more workers nationwide and employ more than 10 employees per store. The Los Angeles County Hero Pay Ordinance does not apply to public entities such as federal, state, or county employees or incorporated cities. School districts and salaried employees who are executives are also exempt. The Los Angeles County Hero Pay Ordinance is jurisdiction sensitive and applies only to the unincorporated cities in the Los Angeles County. These three links that are located on the presentation in blue can be used to determine the jurisdiction and make sure that the Hero Pay complaints that we receive by the Department of Consumer and Business Affairs falls under the jurisdiction of unincorporated Los Angeles County. Under the Los Angeles County Hero Pay Ordinance, businesses must pay $5 an hour in addition to employees' base wage. Employees have the option of receiving their Hero Pay in a form of paid leave, but must put that request in writing form. If an employer has been paying their own hazard pay to their employees, they do get credit for that amount go towards the Los Angeles County Hero Pay amount. This ordinance requires employers to include Hero Pay information on the employees' pay statements every single time. This information includes the hourly rate of Hero Pay, which happens to be $5 per hour, or the amount for the voluntarily hazard pay the employer is providing for the employees, the amount of total Hero Pay, paid leave in lieu of Hero Pay, or voluntary hazard pay earned by the employee, and finally, the number of hours worked that entitles the employee to Hero Pay or voluntary hazard pay in that specific pay period. So all three need to be included in the pay statement for the employees. The Los Angeles County Hero Pay Ordinance also requires the Los Angeles County Hero Pay poster to be posted in a clear and accessible place in workplaces. In addition, retaliation is prohibited under this ordinance. So any employee that speaks regarding Hero Pay, discusses anything regarding a Hero Pay, or reports any complaints of not receiving Hero Pay, no adverse action can be taken against that employee and under this LA County Hero Pay ordinance. The Department of Consumer and Business Affairs has been authorized also to investigate any alleged violations of the Los Angeles County Hero Pay ordinance. The DCBA may issue a wage enforcement order, assess fines payable both to the county and or to the employee, and also help get the employee reinstated back to their job if they have been fired from their job. An employee also has a 3-year window to sue the employer in the Superior Court of California and may be awarded such things as reinstatement back to their job, back pay, lost wages, interest on all due and unpaid wages, and any attorney fees that they have endured during the time that they've been suing their employer. To ask any questions or report any violation Violation employees or other parties may contact the DCBA by calling us at 1-800-593-8222. Again, visit our website at www.dcba.lacounty.gov or email us directly at heropay@dcba.lacounty.gov. So that includes the HeroPay ordinance. Now I will be addressing the employee paid leave for expanded COVID-19 vaccine access ordinance. So this urgency ordinance required private employers in unincorporated areas of the Los Angeles County to provide paid leave for employees to receive the COVID-19 vaccine. This ordinance will be in effect from the dates of January 1st, 2021, all the way to August 31st, 2021. To apply for this ordinance, employees must be full-time or part-time. Employees must first exhaust all their paid leave time under the Labor Code Section 248.2, and employees must provide a written verification that they have received the COVID-19 vaccine to their employers. Full-time employees are given 4 hours per injection. Part-time employees are given prorated amount of 4 hours based on their normally scheduled work hours over the 2 weeks preceding the injection. So for example, if they work 10 hours in a 2-week period, they get 1 hour. An employee who receives the COVID-19 vaccine paid leave shall be compensated at their normal rate of pay. Some of the other requirements under this ordinance includes employers must display the poster for the vaccine ordinance. Employers must keep and allow access to accurate and complete payroll records for at least 4 years. Retaliatory action, again, is prohibited under this ordinance. Employee has a private right of action. They can file an action in the Superior Court of State of California. And DCBA has the authority to investigate complaints or alleged violations of this ordinance. Again, if you have any questions or want to file a complaint for this ordinance, you may contact the Department of Consumer and Business Affairs at 1-800-593-8222. Visit us at www.dcba.lacounty.gov or go ahead and email us at wagehelp@dcba.lacounty.gov. Thank you very much, and that concludes our presentation for today.